And it is good to have you join me again on Business Insight. I am Olaoluwa Awe. In the previous episode, the conversation was about commercial law and the key elements of business contract. Today, we will focus on negotiating contract terms, the legal consequences of breaching a contract, and the role of confidentiality, and more. But one thing comes first on Business Insight, the business news. Let's get to that. This is the business news on Business Insight. I am Olaoluwa Awe. The head of the Lagos Metropolitan Transport Authority, Lamata Abimbola Kiajo, says the Blue Line rail system will start operating on September 4, 2023. When she made this announcement during a media briefing at the Marina Terminal, she says the cost for a trip on this line will be 750 naira, and the state government's 50% fare reduction for government transport will also apply to the Blue Line. Operating during morning and evening hours, the service will involve frequent checks throughout the day to ensure operational efficiency and safety. The system's schedule will be fixed, accessible at stations and online, and will run from 6:30 in the morning to 10:30 p.m. The Blue Line's route spans 27 kilometers from Okokomaiko to Mile 2, extending to Marina via Ijora. However, only the 13-kilometer Marina to Mile 2 phase with 5 stations is currently operational. The second phase will further extend the line to Okokomaiko in Ojo. And away from that, the Cinema Association of Nigeria, CEAN, is offering Nigerians the chance to watch movies for just 1,000 naira on Saturday, September 2, 2023, in celebration of the National Cinema Day. This special offer aims to revive interest in cinema attendance and thank loyal moviegoers for their support. Over 50 cinema locations with more than 100 screens nationwide will participate in this one-day event. The initiative follows a 14.98% decline in box office revenue in Nigeria for July, attributed to various factors, including a series of public holidays. Meanwhile, the highest grossing Nollywood movie of 2023 have been revealed by the Cinema Exhibition Association of Nigeria. Orisha, directed by Odunlade Adekola and produced by Film One Studio, takes the lead with a gross of 60 million naira. The movie narrates the tale of an exiled king who faces turmoil and insanity after losing his crown and deity. Following closely is The Kujus Again with 53 million naira, a sequel depicting a family's attempt to mend differences amidst chaotic wedding planning. Biodun Stevens' Big Love secured 47 million naira, portraying a love story between Timini Egbusin and Bimbo Ademoye, while Love in a Pandemic garnered 46 million naira, and The Bride Price garnered 30 million naira, depicting romantic narratives against the backdrop of challenges. And away from that, in July 2023, the Debt Management Office DMO of Nigeria sold treasury bills valued 406.10 billion naira throughout auctions, representing a 0.39% month-on-month increase. Additionally, the DMO reopened 10-year, 15-year, and 30-year FGN bonds worth 657.84 billion naira, which saw a 182.73% oversubscription and a 39.03% month-on-month increase. The second market turnover on the FMDQ exchange for July 2023 was 19.92 trillion naira, experiencing a month-on-month decrease of 8.37%. The spot FX market turnover was 3.61 trillion naira, $4.66 billion in July 2023, with the US dollar appreciating against the naira. The United States has announced a collaboration with Kenyan coconut processor Kentest aiming to boost the local coconut industry and create economic opportunities for over 4,500 farmers. Backed by a joint investment of over $1.6 million from the United States Agency for International Development, USAID, and Kentaste, the partnership seeks to expand Kentaste's exports to the U.S. The initiative is expected to increase Kentaste's processing capacity by 67%, generating 90 full-time jobs and enrolling 4,500 new farmers as suppliers, or enrolling 1,500 new farmers as suppliers. The collaboration also establishes ties with major U.S. retailers to carry Kentaste coconut water products, enhancing access to the U.S. market and promoting local employment. The UAE's foreign trade without oil reached a new high of 1.24 trillion dirham in the first half of 2023, which is a 14.4% increase compared to the same time in 2022. The leader of the UAE, Sheikh Mohammed bin Rashid Al Maktoum, said the country's exports are growing and have increased by 22% with its top 10 trading partners. This shows that the UAE is an important player in global trade, connecting different parts of the world. Also, UAE's strategy for balanced trading is successful, and non-oil exports are a big part of it, making 205 billion dirham in the first half of 2023, up by 11.9% from the previous year. Its main trading partners are China, India, and the United States, Saudi Arabia, and now Turkey after a new agreement. Gold, aluminium, oils, and other products are the main things the UAE exports. Gold exports have grown the most by 40.7%, reaching 218.3 billion dirham. And away from that, England has equalized women's international match fees with their male counterparts, a major step towards gender parity in sports pay. The England and Wales Cricket Board, ECB, announced that women's match fees will be immediately brought in line with the men's, amounting to approximately £12,500 per test match, £5,000 per one-day international, and £3,500 per T20 international. The move follows the successful Women's Ashes event and aligns with the recommendations of the Independent Commission for Equity in Cricket, which identified discrimination in the sport as widespread. The ECB aims for further equality with Project Darwin, which aims to have equal pay in all domestic cricket by 2028 and in the 100 by 2025, where men are currently earning £125,000 and women earn only £31,250. The value of Bitcoin and other cryptocurrencies went up because a United States court has made it okay for U.S. residents to have a Bitcoin investment fund. This pleased cryptocurrency investors and made it tough for those who try to control them. Bitcoin's price increased by 7% to around $28,000. This new fund allows regular people to invest in Bitcoin without owning it directly. The court's decision was expressed in a victory ruling for Bitcoin company Grayscale. The court panel had overturned the Security Exchange Commission's denial of Grayscale's Bitcoin fund, saying the regulator couldn't explain well why it was rejected. On that day, nearly 20 million Grayscale Bitcoin Trust shares were traded, the most since a crypto market crashed in June 2022. The share price rose by 18% to almost $21, the highest since Bitcoin hit $31,000 in mid-July. However, Bitcoin is still far from its highest value of over $68,000 in late 2021. But with that, we delve deeper into the capital market, so stay tuned. At the end of the last full trading day, August 30, 2023, on the Nigerian Stock Exchange, NGX, a total of 637 million shares were traded in 10,033 deals, valued at about 7.8 billion naira. This is a 46% increase in trading volume, 11% increase in turnover, and 26% increase in deals compared to the previous trading day. The overall market value of the Nigerian Stock Exchange is now around 36.4 trillion naira. A total of 118 listed equities were involved in trading, with 27 gainers and 24 losers. Capital Hotel saw the biggest gain with a 10% increase in share price, followed by Consolidated Hallmark Insurance 10%, University Press 9.77%, and Champion Breweries 9.72%. On the losing side, Transco Nigeria had the largest decline with a 9.99% decrease in share price, followed by Computer Warehouse Group 9.88%, Ikeja Hotel 9.84%, and FTN Cocoa Processors 8.11% loss. The stock with the highest trading volume was Transco Nigeria with 292 million shares, followed by Access Holdings 26.7 million, Dangote Sugar Refinery 24.5 million, and Jay's Bank 18.7 million. Moving on to the Malawi Stock Exchange MSC, a total of 665,183 shares were bought and sold, valued at over 70 million Malawian kwacha. The entire value of all listed companies on the Malawi Stock Exchange is currently 6.44 trillion Malawian kwacha. In total, 8 different companies on the MSC were involved in trading yesterday. Among them, 3 companies saw their stock prices rise, while 2 companies experienced a decrease in stock prices. FMB Capital Holdings had the highest increase, with its stock price going up by 14.65% and closing at 400 Malawian kwacha per share. Airtel Malawi stock increased slightly by 0.02%, and Illovo Sugar's stock remained unchanged. On the other hand, Telecom Networks Malawi stock decreased by 0.03%, and FDH Bank stock went down by 0.01%. Telecom Networks Malawi had the highest trading volume with 394,591 shares traded, followed by FDH Bank with 101,177 shares, Airtel Malawi with 83,925 shares, and FMB Capital Holdings with 50,500 shares. Now let's get to the latest development within the commodities market. Wheat's value stands at 575.5 US cents per unit. The lasting attraction of gold remains evident as it commands a substantial price of $1,944.91 US per ounce. Silver seems to be mirroring gold's trajectory with a valuation of $24.78 per ounce, and copper is slightly lagging, priced at $3.79 per pound. Turning to the energy sector, Brent crude oil is currently valued at $85.22 US. And away from that, we go to the dynamic world of the currency exchange in Nigeria. The parallel market shows the naira against major international currencies. For those eyeing the US dollar, it is set to be 915 naira for buying, while selling is at 920 naira. Across the pond, the British pound paints a distinct picture. Those considering a purchase will find it at 1,160 naira, whereas sellers receive as much as 1,170 naira. Meanwhile, the euro sets its price at 980 naira, and sellers can anticipate 990 naira. These numbers show how the naira's value changes when compared to money from around the world. The parallel market can be quite unpredictable, we say, so the prices go up and down a lot, and this is something people who deal in different types of money need to watch out for as they sell. As the rates move, it's really important to keep knowing what's happening, and this helps in making good choices for your business. And on that note, we end the business news on Business Insight. Next on the program is more conversation on contract with Mr. Adesola Fagbemi, where we'll also talk about non-disclosure clauses in safeguarding sensitive information, the inclusion of termination and renewal clauses in contracts, the importance of including dispute resolution mechanisms, the legality and benefits of using electronic signatures in modern contract management, the unique challenges and considerations in international contracts, and such as jurisdiction, applicable law, and cultural differences. So join us for this exciting edition. And this is the segment I have been talking about since Business Insights started today. Once again, I am Olaoluwa Awe, and this is where we further the conversation on commercial law, especially business contracts. And yesterday we were able to identify the key elements every main contract should have. And these are the things that will make your contract enforceable in the case of a breach. We explained what a breach of contract also is yesterday, but following the conversation this morning, Adesola Fagbemi, our legal practitioner and a litigator in corporate commercial transaction, will join me right about now. Good morning, Mr. Adesola Fagbemi.
Thank you very much, Olaoluwa.
Yes, I remember vividly that yesterday we were trying to explain the different types of contracts that we have. And that was where we had to wrap up the show. So we're going to take it from there. We're talking about the different types of business contracts we have and the unique differences in these different types.
Thank you very much once again. As I said earlier yesterday, continuing from here, I told you that we have several types of business contracts that could exist. We have a business contract of JV. We can have joint venture agreement is a business contract. Joint development agreement is a business contract. And sale of goods or carriage of goods by sea, by land, they are also a form of business contract. Purchase agreements, sales purchase agreement, the business contract, even to deed of lease. We have several leases. They are contracts in nature.
Could you please
also
explain
landlord tenancy?
Could you please explain what those documents or those contracts are really about?
Definitely, you know, those documents as they were, they are kind of agreements. You know, when you say contracts, that is legally binding between whichever parties that are involved. They are basically legal contracts which are legally binding, enforceable, whenever there's a breach of that legal obligation to do.
Yeah, I asked that question so that people can understand the parties involved in the different type of contracts that you have mentioned.
Okay, let me bring it down to the issue of, let's say, deed of assignment. There are two parties in deed of assignment. It's a contract for the sale of land. You have the buyer and the seller. Okay, if there's a kind of joint venture agreement, is another form of contract, maybe to build a property. Two parties are involved. Sometimes it could be more than two parties. It could be tripartite agreement depending on the number of parties that are involved. But the usual one that most people could relate with is the sale of land, especially in Lagos. You could see parties coming together. The buyer will show intention to buy, while the offer to buy will be from the seller. And once the purchase price is met, then there's a contract. Then there will be transfer of title. But it goes further in a complex commercial transaction scenario where there is service contracts. Service contract is for a professional organization rendering a kind of service, professional service, to another organization. And two parties could come together, or three parties could come together to consummate such a contract deal.
All right. I think we have an idea into the parties involved in some of the contracts that we have. Really quite interestingly, there are a good number of them, and thank God that Mr. Fagbemi has explained that particular one. But it is now time for us to get to negotiating contract terms. You know, why is it very important for negotiation to happen? And what are the processes of negotiating contract terms between two parties?
Thank you very much for that question. It is essential for parties to negotiate contract terms in order to foster business deal and operation. You know, the aim of every organization is to make profit. And when turnover is being affected, then the business cannot survive for too long. And the cost implication, you know, we always look at the cost implication that will foster parties to enter into contract terms. You know, if those terms are not properly, you know, construed, then it could be costly. So it's always advisable to look into various clauses in contractual agreement, ensuring that it's pave a way for a profit turnover in the end, rather than leading you to end in litigation and losses.
Because what some people do is that at the point of drafting the contract, or before you even get to the point where you put it in paper, you know, and if the first party is offering certain things that they feel like is not enough, or they're not satisfied with, instead of them to voice out, open up, and be very honest about what they want to get out of the contract and what they are willing to give, they keep quiet, and they eventually face troubles later in that business deals. So how also do you manage a negotiating process where you can't seem to find a common ground? Or how do you ensure that, despite the fact that the other party is giving you offers that you're not quite satisfied with, how do you ensure that you find a common ground in all of this so that both sides are really happy?
Thank you so much. Basically, you cannot be contract shy. When it comes to negotiated agreement, you want to enter an agreement, it is advisable to look for an expert or a negotiator who could negotiate if maybe there's a breach of contractual terms, parties have moved beyond that and have been on negotiation table. If you want to negotiate the contract term, you must get an expert. You shouldn't be positioner, you know. You shouldn't be positioner. If you are too positioner, negotiation will oftentimes break down. But when you employ a kind of principle method of negotiation, because there are two types of negotiation technique, which is positioner and principle. If you tilt towards principle way of going away and going about negotiating your contractual terms, then parties could reach amicable settlement or resolution that is mutually beneficial for party, and which is usually cost effective compared to other ADR spectrum. You know, we have alternative dispute resolution, and it has a broad band.
Well, you mentioned two types of negotiating now when it comes to contracts, the principal and the positional. Are these speaking to the factors the parties need to consider before taking offers, making offers, or reaching an agreement with the other party?
That one, I think where you are coming from, you are talking about the initial stage where contracts is to be consummated.
Yes.
And I think I did touch that a little. I said it's always good to employ the service of an expert who will be able to, not to be contract shy, be able to say everything on their mind. Because, you know, once parties had entered into a contract, it is mutually binding. And you cannot say, oh, it's because you forgot to say something. Everything, all ambiguity would have been discussed. You would have known your needs. What are your needs? What are your position? You would have come in time with, let's say, something like your trade, where the kind of trade that you are embarking on or that you are carrying on. You would know your business objective, and in line with that, would have, you know, structure the contract with it. But you have to leave it in the hands of an expert, a legal practitioner, who advise adequately on all those clauses to be factored in a contractual agreement.
Thank you very much for that. You know, one lesson that I picked from all of that is that it is very important to know also the principle of your business or your company, and you ensure that whenever you are going into negotiation, some of these things don't go against the foundational principles that you work with as a business. Because eventually, if you go into that contract, you will eventually feel like pulling out because it will not work for what your business stands for. But a good number of people just sign contracts because they feel like, oh, this person has the upper hand. They go into deals out of desperation, the desperation they are feeling at that moment. But eventually, if you don't sort some of those things out, even within you and at the negotiation table, you will eventually fall into trouble. Because if you eventually get bound by that contract, when the deal stops working for you, you will still have to hold up to your own end. And that is why a good number of people get into problem. They make promises, they eventually can't, you know, provide one of the things that they have promised to provide. But let's now talk about confidentiality and non-disclosures. What role do this play in contracts?
Thank you so much for that. In drawing up a legal contract, NDA, we call it non-disclosure agreement. You know, you could have non-disclosure agreement that will protect your business objective, your patents, whatever that you know that has given you advantage, opportunity that are putting on your cutting edge over others. You can protect it by drawing up a separate agreement, non-disclosure agreement, or you can insert the clauses in the agreement depending on how it will be structured. And from the outset, non-circumvention clauses must also always be retained in a commercial contract. Commercial contract has a broader view, but in some certain instances, you have to protect your trade, your line of trade, your patent, and what have you. Is essential at all times to retain it in a commercial contract.
Now, what is the consequence if such clause is breached by the other party?
Sorry, come again.
I said, what are the consequences when you have drawn up a confidentiality document or a non-disclosure and the other party breaches the clauses in this contract?
Okay. Straight away, is for you to go to court, approach the court to enforce your rights. And it depends on the kind of commercial contract you have entered into. Enforcement may not necessarily be a matter of court at first instance. If there's an arbitration clause inserted in the commercial contract, you can first of all explore arbitration or mediation. Mediation clause will also be retained in a commercial contract. But the most important thing is when there is breach of a contract, you have a right retained within the contract to enforce it. And mode and manner of enforcement has a broader view.
Now, what is the role of including a termination and renewal clause in a contract?
Termination and renewal clauses are also clauses that should ordinarily be retained in a commercial agreement, because if you are opening your commercial agreement, it must have a commencement clause. When there is a commencement, we have parties, then there will be a commencement clause. Proceeding everything, anything that starts must end. But you don't throw your contract to be just open. It must have a commencement. We have the case of Busa and Oji that talked about that whenever you are drafting up or drawing up a commercial contract, must have a commencement. And termination clauses are also essential in times of breach or commercial, breach of contract or non-performance of the fundamental clause or terms of the contract at some point.
Thank you. Because I want us to now get to how to enforce contract breaches or how to enforce contracts in the law court. I know we touched on that yesterday. But before we get to that, let us talk about dispute resolution mechanisms. In situations when things go sour, are there no ways to mediate and work around things without getting to the point where you go to court?
Thank you so much. Enforcement of the contracts has a provision generally within the jurisprudence of Nigerian law. In Lagos State, we have High Court Civil Procedure Rules that retain provision for arbitration, mediation. In the extant, we have section Order 27 and 28, and those concepts have been laid down. Within the ADR spectrum. The ADR spectrum is so wide and vast that litigation is not the only option. As I said earlier, even we have the AMA of 2023, Arbitration and Mediation Act of 2023 that have come into force, that has been gazetted. There are some complex commercial transactions that envisaged that you don't proceed to court immediately. You have to explore alternative dispute resolution. And ADR spectrum is so wide that you have to explore it one after the other, so that you will not run foul of commercial agreement you have entered into. It's a contract which is enforceable. If you run to court, to enforce your right, why you have to first of all submit yourself to arbitration or go to tribunal, as the case may be, in conciliation. And the 2023 AMA does not even envisage conciliation. It has disappeared. But in the previous Act, 2004, laws of the Federation retain conciliation when it has to do with trade disputes. But in current law, as we have it, litigation is also an option. One of the one of the ADR mechanisms put in place. And we also have mediation. I've done several mediation at each point in time, and I know which is cost effective, which you should be thinking of using at what point. You can submit yourself to mediation at the initial stage. We have also court-connected mediation session as envisaged by the rule of the court. You may approach the court by, first of all, filing your processes in court. While getting there, at some point, court can refer parties for mediations to explore disputes, settlement through mediation. We have also negotiation. I think negotiation is very cost effective because it involves two parties to sit. It will not necessarily be a thing of court, can negotiate and without even costing you anything. Why mediation is also a very good one, which works for parties. In land matters, we have done it. In complex commercial transactions, we have also used it as a mechanism for enforcement of parties' rights.
Now, let's look at the practicals of the things you have mentioned now, the mediation, negotiation, and all of that. For example, if there's a situation where a company introduces like some sort of capital investment opportunity to the public, like we see from time to time in Nigeria. They promise you, we'll give you 25% interest on your investment every month for 1 year, for 5 years. You know how these things go. And eventually you subscribe as a party, you sign documents, and the first month, second month, up to the 6 months, they own up to their own part of the contract. But after the 6 months, things begin to go sour. So in that situation, how do you advise the party, which is the investor now, to go about things? Because we see cases like this from time to time in Nigeria and in other parts of the world. Another instance is a case where you buy a vehicle from a party and you sign documents, contracts, and so on and so forth, only to discover that the vehicle ends up not being in the kind of shape the seller promised it will be. For example, maybe you had done initial testing and things looked okay, only for you to discover that maybe a day or 2 days or 5 days after you tested, certain other things started coming up. How do you advise such a buyer to move forward in such a situation?
Thank you very much. It's a very good question. These are things that investors or subscribers to maybe shares or bond, these are the things, the occasion in Nigeria of today. And my first advice is to, first of all, when there is issue like that, you can seek the service of a legal practitioner who will find a way to write the organization. If it's a public company, you have to write them letter of demand, notifying them of their obligation. And if they didn't respond within 1 month or after the expiration of 1 month, you can commence a legal proceeding against them. But you have to put them on notice. In Lagos State Civil Procedure Rule, there is a provision for pre-action protocol. When you talk about pre-action protocol, you have to put the other side on notice. You don't just burst into the court and start enforcing your matter. Your case may be dead on arrival. So you have to, first of all, take the initial step. With respect to maybe a buyer or a purchaser of a good, let's say a car, as we have given the example, and maybe he has, met the purchase price, he has paid, and after 3 days, the car starts developing faults. We have a Sale of Good Act, 1893, that are laid down all this foundation that whichever purchaser of value or of goods, at which point is purchasing, must purchase a very good goods that is in conformity with specification, standard. We have Nigerian Standard Organization also provided for that. And recently, we have Federal Competition and Consumer Protection Act of 2019 has also, laid down the foundation that consumer of goods, be it perishable, be it non-perishable goods, must be protected, so that there will not be a kind of misrepresentation of facts to them or misleading facts just to deceive them to enter into a contract obligation, and they can't get value for their money. In the event that things like that is going sour, let's say a purchaser of a car cannot get value for his money, you can write, first of all, and notify whichever person that has been in breach or in continued breach of your intention to litigate or to file legal action against whichever party. You can proceed to court and cover damages. And all the options provided by the ADR spectrum are also available in such instance.
Oh, okay. So you just mentioned the ADR spectrum once again. I was about to ask, what's then the place of mediation, negotiation, all the options that you have to explore before you get to the point where you go to court?
At each point, it depends how creative you are, and whichever lawyer that is advising, the lawyer would have looked at the agreement, if there is an extant agreement or a contract, then you will be able to now look at it and say, okay, this is the first option, this is where to go. That you always involve the services of a lawyer so that everything will be done appropriately or in tandem with the extant law. In commercial transaction, we cannot say this is the thing to do first, but usually in everyday thing we do, negotiation is the first option. When you are dealing with a car dealer, is efficient, cost effective, and you can also retain your relationship if it's done properly, provided you are not pushing your position too much. You must know the need of the other party and must be an empath. You don't have to be sympathetic. You must not be judgmental. A good negotiator must have such qualities to look at the need of other parties. And there are models that we employ, the onion model, look intently, the donut model. We have those models that could be employed.
Thank you.
And
now,
to be able to resolve the problem.
Let's talk about justice in a case where a contract has been breached. What exactly does it look like in Nigeria, especially when you are trying to enforce your contract or a breach of contract in court? Do you state exactly what you want, for the breach of contract, or will the court just award you what is just? And how long does it take? Take us through that process.
Thank you so much for that question. There have been plethora of Supreme Court decision on that subject, that the Supreme Court or court generally is not a Father Christmas. Whichever person that has suffered damages and is approaching the court for restoration or for damages or to be restored to the original state it was before he suffered that breach, must present before the court what his prayers would be. Whatever claim that it is, must be specifically pleaded, in court. All details must be, pleaded, must be stated. Not general environments, as lawyer will say, not general environment, but specific. You have to be specific. Those claims must be specific, and they must be realistic. Because once they are not realistic, they will be thrown out.
Wow.
Or if they don't support any extant law, can also make a case not to be successful.
Well, is that the reason why we have it in some cases when a party will sue another party for whatever reason, asking for a certain amount of money, and we'll discover that even though it wins that case, the court awards a smaller amount of money to the person who is in breach of contract in that case?
In Evidence Act 2011, there are some things written in that Evidence Act that you must prove. He that alleges must prove. If you are alleging that somebody has breached some fundamental or express term of contract or implied term, you must be able to prove. He who alleges must prove. And there are also cases that in support of that. Whatever you are alleging, you should be able to prove. You're asking for general damage, general damages. Those general damages are things that you can ask for in court ordinarily, but to some certain extent, you must be able to say. But when it has to be, let's say you are claiming for special damages, you have to, you have to prove every details to court. You have to prove it. You have to itemize it in your pleading and set them out seriatim before the court can look at it and look at it again and say, okay, I can award this certain amount
So the other
as a special
party.
damage. But if you are unable to prove specifically, then you will not be successful.
Now, let's talk about maintaining proper documentation and actually keeping your contract. For example, if I enter into a contract with you and we both sign and I misplace my copy of the contract, is the contract still valid?
Very valid, very valid. The counsel or the attorney, legal attorney acting on your behalf, if it's maybe an organization, even in instance of a sole proprietor going to court, maybe to enforce his rights, you can put the other party on notice to produce. These are extant law within the Evidence Act 2011, to produce the original or to produce a copy. So you cannot say because you have lost a certain document, there's no contract.
What if the other party denies
So
ever going into a contract with you, since you don't have your copy of the contract?
It's always good, so to speak, to have a proper documentation. It's an era of cloud where you have to, whichever contract you are entering into, your lawyer will have a copy, you have a copy. Those counterpart copies can also be, stored in the cloud, Dropbox, and the like. So I think proper documentation will ensure that you don't run into so much stress. Let's say, for instance, in Lagos State, you can see during the NSAS, courts were burnt, and as a result of lack of proper documentation on the side of Lagos State judiciary and those people who have been saddled to to keep records, they lost so many records due to that. They lost so many documents due to that saga. So the importance of proper documentation cannot be overemphasized in age like this. We have cloud, Dropbox, where you can keep your documents, but you can always go to court and put the other party on notice to produce at some point if you cannot lay your hand on certain documents.
But on a lighter note, is the photocopy of a contract as valid as the original?
Very well. Photocopy, it's all about an evidential thing. When we go to court, there are ways of proving all these or tendering documents. When you want to tender documents, if the original cannot be found, you can tender the photocopy of such document, and it is still valid as an original. But there are ways and manner to tender such document when you are dealing specifically with corporation or public company, like government documents. Proper custody, the issue of proper custody and the like we look at. And the foundation, as the case may be, must be laid before such documents are being put. And in some instances, you have to make some certain payment and show proof of payment that you have actually applied for the CTC. You can apply for certified true copy of a document before it to be tendered if the original is missing.
Now, as we wrap things up on today's program, let's quickly talk about contract modification. For example, at the beginning of your deal, you had a contract, but towards the middle, you discovered that certain things need to be changed or adjusted based on the realities of your business activities. How do you go about that?
Thank you so much. It depends on the nature of that contract as it is, and the clauses retained. The clauses retained in the body of that contract. If the contract envisaged that there could be amendments at some point, there could be a kind of trying to track some fundamental things in the body of the contract, then it is possible that parties can come together and to reconsider some certain clauses in that contract.
Thank you.
But if the contract has not envisaged that, it is unclear. I'm not sure that the other party want to budge and accept that some certain things are taken out of the contract.
Thank you very much.
It has been mutually executed.
Thank you very much. It's been an amazing time with you, Mr. Adesola Fagbemi. He is a litigator, a lawyer in commercial law here in Nigeria. Thank you very much.
It's a pleasure.
And that's how we wrap up today's episode of Business Insights. Hopefully, the next time we have this program, we'll look at another area of business law, which is very, very important because, people get into trouble from time to time in their business just because contracts are not tidied up. They are breaching different aspects of the law as it pertains to business. But we are here to prevent that and help you work around it, even if it happens. My name is Olaoluwa Awe. Thank you very much for watching. That marks the end of the program. Have a nice day.